All right. Good afternoon, everybody. My name is Devin Marr. I'm a lawyer at Strickberger Brown Armstrong, which is a litigation firm focusing on insurance defense. We've got three offices in Toronto, Kitchener-Waterloo, and London. Uh, our practices are mostly insurance defense litigation, first and third party, pretty much everything from bodily injury to CGL to cyber and privacy. Um, Today's presentation is dealing with defending claims and handling claims for employment wrongful acts. And as you can tell by the title, it's basically going to be tips for liability adjusters on what you need to know and some of the things that make these claims unique. Like I said, my name is Devin Marr, and I'm a lawyer here at Strickberger Brown Armstrong. You'll see on the slide here my colleague Ariana, who I can give some credit for making the slides and helping get this presentation together, but she won't be presenting today. It will just be me. So for today, my practice is fairly general insurance litigation. I do a lot of first and third party claims, but I tend to focus these days on employment practice liability claims, really anything that has an employment focus or really a human element. I seem to be roped into it. So if it's a workplace, I tend to be there. So what we're going to talk about today, and I should say, if you have questions, there'll be a Q&A session at the end of this. You can just type them into the Q&A chat. It'll be at the bottom of the screen here. If the session is being recorded, so just be aware of that as well. And if you need a copy of the slides, feel free to reach out to me after the presentation. I'll happy to send you a copy and email them, and it will be put up on the recording will be put on our website in a couple weeks. And so in terms of our introduction, this is the roadmap. We're going to talk about what are employment wrongful acts, some of the unique features of handling these sorts of employment practices liability claims, as they're called. And then, of course, the third part is going to be talking about practical handling tips. And hopefully we'll take you through all of this in about 20-25 minutes with a little bit of time at the end. So when we talk about employment wrongful acts, the goal for today is really just give you a bit of an overview because these are a really interesting set of claims that are increasingly covered by a wider variety of policies. There is increasing coverage for it these days. It's been very popular in the US for a number of years. And in the last decade or two, it's been becoming more popular in Canada. And insureds are also becoming a little more aware that this coverage exists. So we tend to see these issues coming up a little more frequently because insureds are making claims. And when we talk about insureds and we talk about employment wrongful acts, we are talking about, your insured who is likely or alleged to have condoned or actually done an employment wrongful act. And so it's usually a claim that's brought against your insured by an employee or a former employee or sometimes just third parties. And so you'll notice on the slide that there's no standard definition. EPL policies, employment practices, liability policies, they're all a little bit different. I don't think I've ever seen two definitions that are exactly the same. But in terms of general characteristics, they deal with claims that arise, in the course of employment or from employment. So oftentimes the policies will say we will cover, claims brought by or on behalf of any past, present, future employee or potential employees of the named insured. And your named insured is usually the organization. And so where do we sort of find coverage for these claims? These claims, they're often a standalone policy. You have employment practices liability policies. I know several insurers sort of have them as a standalone. A really common place for them to also be is as an endorsement or a sublimit under a D&O or management policy. That's often where I get most of my claims. And more I'm seeing, some claims for, these comprehensive condo policies that you'll see, which have, D&O elements to it, and they will usually have that employment practices liability coverage there. And so when we talk about employment wrongful acts, what are we talking about? And the core employment wrongful act in Ontario is usually what you hear, wrongful dismissal. What is wrongful dismissal? And in Ontario, every contract of employment, every employee and employer, have in their contract, whether it's written or otherwise, an obligation to provide an employee with a reasonable notice of their termination. And what reasonable notice means, as an example, is, hey, Bob, you know what, in 4 weeks, that's your last day. And that is, notice of termination. You can also have pay in lieu of notice, which is, in that situation, hey, Bob, today is your last day, but we're going to keep paying you for the next 4 weeks. And the core dispute that comes up in these claims is almost always about, is there enough notice given? But even though this is sort of the core issue, that's not the main issue that these sorts of claims deal with. And quite frankly, these claims are always complicated, and I'll go through a few examples in a minute. But when we talk about how these policies are triggered, there's a duty to defend. And it's not just reasonable notice. It's things like allegations of discrimination or harassment, employment-related misrepresentations, any failure to implement policies or follow policies correctly. Your insureds, it's rarely just about the notice. And this is what sort of makes claims tricky, because when we go to the duty to indemnify under these policies, what the insurer actually has to pay and cover, most of these claims or most of these policies tend to only cover legal expense, the legal spend, usually defense costs. The actual damages portion of the claim, so the reasonable notice, which is a breach of contract issue, tend to not be covered by the policies. The insured is on the hook for that. And that can lead to some tension, as we'll talk about in a minute or two. Some policies are changing. Some will pay part of the indemnity, or they'll pay certain heads of damages. But by and large, these policies cover the legal spend. So, appointing defense counsel, paying for the defense counsel, and having them shepherd you through. And the insurer generally still does get to manage the defense. So why am I doing a webinar on this? It's employment law, we're doing liability work in insurance. What makes EPL claims unique? And I originally had the slide saying employment law is weird. I think maybe employment law is complicated is probably a more appropriate example, because while the core of it's this breach of contract, wrongful dismissal issue, there is a massive overlap between contract and tort claims. Employment law is starting out fundamentally as contract law, but over the years, courts have decided or read into employment contracts certain obligations. There is a duty of good faith in the manner of dismissal in employment claims, which is similar to the duty of good faith between an insurer and an insured. It's not quite as onerous, but it's there. There are good faith duties. If there is a tie in interpretation, the tie generally goes to the employee, because the courts tend to favor the employee as having lesser bargaining power. And invariably, you're going to see tort claim or EPL claims that have the wrongful dismissal element to it, contractual damages, but they're almost always going to have tort claims attached to it. And we'll talk about some of the examples in a minute or two, just to give you a sense. And because each one is so different, because their two claims are the same, the sort of cookie cutter approach or of handling a file or handling your insured doesn't always work. I do auto BI as well, and obviously, the claim comes in, you talk to the insured, but the insurer tends to run the show because they're on for everything. So it's a little bit different when we talk about EPL claims. And so to give people a sense of why employment law is weird or complicated, I've put on the slide some of the classic examples that we see in EPL claims. And I will go through some of the examples. And the hope here is that you start to realize that it's not just about the employment contract. You'll always have something else, which makes them amazingly interesting to work on, but they're always a little tricky. So, when we talk about breach of contract, it's pretty straightforward. It is the wrongful dismissal I've been talking about. When we talk about a breach of good faith, those classic examples might be, when you fire someone who's worked for your company for 30 years by screaming at them in the middle of the open concept office and then frog marching them out by security. That would probably attract a claim for the duty, a breach of the good faith duty in the manner of dismissal. Apologies if you hear some sirens. When we talk about discrimination, in Ontario, and I have to be very clear about this, there is no tort of discrimination. You can't just bring a lawsuit for discrimination. But since some amendments about a decade or so ago in the Ontario Human Rights Code, Section 46(1) allows someone who believes that their rights under the statute have been infringed to attach their human rights claim to a court action. As long as they have another freestanding tort or contractual claim, they can bring a human rights claim to court. And so the classic example is someone's dismissed, they claim they didn't get paid enough notice, and they also claim that they were dismissed because they were pregnant or they had a disability or sexual orientation or one of the protected grounds. And this can be really interesting from a coverage perspective because a lot of policies, I've had these discussions with insurers as well and underwriters. They say, oh, we don't cover human rights damages because our policy, or human rights claims, because our policy doesn't cover any human rights damages ordered by a tribunal. Well, with Section 46(1), the courts are empowered to order damages the same way the tribunal could. So now you have human rights damages being ordered by a court. And so, it does require people to sort of take a second look at the coverage issue. And so, defamation comes up a lot as well. So the two main examples I've seen are you have employees who get a bad reference letter from their former employer and they sue them for defamation. That is a claim, that's related to employment. Whether or not they'll be successful is one issue, but this is a case that has happened. Another situation where a defamation claim can come up is where the employer has dismissed someone and has alleged that maybe they were engaged in a fraud, a kickback scheme or something illegal and inappropriate. Whether or not that's true, you may receive a defamation claim in addition to the standard wrongful dismissal claim. When we talk about intentional infliction of mental suffering, this tends to deal with harassment, because in Ontario there is no tort of harassment. But the conduct is sort of caught under here. So if you have a high-level executive, perhaps a movie producer who was engaged in a campaign of inappropriate and targeted harassment over the years, you'll probably, you could see an intentional infliction of mental suffering claim. And then, negligent misrepresentation is another claim that we can often see. And the seminal case on this went to the Supreme Court, was about a misrepresentation that was made during a job interview that induced someone to take the job, and then it turned out that it was based off of a misrepresentation. So another sort of claim that you'll see come up under these policies that maybe you didn't expect. And then the last two examples I have, unlawful interference with economic relations and inducement of breach of contract. You know, you'll see this often in sales, sometimes high-level executives. Maybe the insured, the employer, has taken some steps to prevent a former employee from continuing on with their livelihood, and you might see a claim for unlawful interference or inducement of breach. And certainly some of these seminal cases on that are actually employment cases. More recently, we're seeing a rise in sort of newer claims. Those were the classic ones. They've been going on for years. Some more prevalent claims these days are, first, is misclassification of employees as independent contractors, because independent contractors aren't entitled to reasonable notice. They aren't entitled to certain statutory benefits or payments. But the problem is 9 times out of 10, the classification of an employee as an independent contractor, probably not correct. And Uber is your key example. You have a class action that went to the Supreme Court to determine whether or not Uber drivers claiming they were not independent contractors, whether they could bring a class action. And it was for $400 million, and that's still ongoing. We're seeing some breach of privacy claims as well, which usually is a claim by the employee saying that information wasn't safeguarded properly, or a former employee might allege that information was shared to a new employer that was private and shouldn't have been shared. So we see that coming up. But the biggest one, the growth area it seems these days are class actions, because historically employment law, not a big area for class actions. But recently, in the last 5-10 years, we're seeing more and more class actions for things like misclassification of employees as independent contractors, failure to properly pay overtime, or properly paying vacation pay. I think it was last week, the Ontario Court of Appeal upheld a class action decision against CIBC for failure to properly pay overtime since 1993. So, massive claims. And then we're seeing claims for reprisals for trying to exercise your rights under various employment statutes. So those are becoming more common, and they're sort of getting tossed in as well. And so when we talk about damages, it's good to have a sense of what exactly these claims generally claim. And while some policies won't cover indemnity for damages, some will. So your common issues are breach of contract, your general damages, and we'll give some examples in a second. You'll see aggravated damages, so damages for mental distress usually, which bad faith in the manner of dismissal. You have these human rights damages that can be brought in by statute, and then punitive damages as well, when the employer wants, or the judge wants to essentially punish the insured or the employer for high-handed, reprehensible conduct. And so just to give you some examples in these slides, just put up some cases. The first is the Korma decision, came out last year, because when we deal with reasonable notice, it's not just your salary, it's anything you would have been entitled to for that period of notice. So in this case, the employee was entitled to their 19 months of salary, but they were also entitled to damages that were the equivalent of 10% of the benefits they would have been entitled to had they still been working during that notice period. The next case, the Robinson case, the plaintiff was entitled to $45,000 in the expenses she incurred to mitigate her losses. She had to move to another city and sell her house, and there were fees related to the selling of the house that were recoverable. So, it's not just about the notice, it's about mitigation expenses. You'll see aggravated and punitive damages. They are rarer, but they do come up. In the Humphrey case, you had a situation where the employer was found to be in breach of their duty of good faith in the manner of dismissal. They alleged, in part because of their conduct during the litigation, which is always an interesting thing, because the duty can extend into the litigation. In this case, the employer said they had cause to dismiss the employee which is essentially the capital punishment of employment law. And they held that position for about a year into the litigation. And the court essentially, and there was no evidence really to support it. And so the court awarded additional damages because they felt that was in bad faith. And so you have to be careful with your litigation strategy. And then the Altman's case is one where the employer was essentially behaving poorly towards an employee who was recovering from cancer, and essentially withheld wages, and found that the failure to properly pay wages attracted a punitive damage award. And this brings us to our part about your insureds and why these claims can be technical. Because of each policy is different, when you send out the initial reservation of rights letter, identifying that there's coverage, you really need to explain the limits of coverage, because the insureds will often be on the hook for a fair portion of the indemnity at the end of the day. Something you might run into is insureds will often use their corporate counsel to try and handle the issue earlier, and this can sort of lead to problems as well as coverage issues if they don't give notice. Unfortunately, I get a lot of things across my desk where it's the insured's corporate counsel has drafted an employment contract, but it doesn't stand up to scrutiny. And it can be really tough to explain this to the insureds who are generally sophisticated individuals and think they've got everything right. And that brings into the point that this sort of tripart relationship, as a defense lawyer, my duty is to the insured, but I obviously report to the insurer because they are entitled to control the litigation. But you have issues where deductibles can be quite high for this, and the insured will often pay the damages while the insurer pays the costs. So you can get into these situations where the insured takes a reasonable position that is recommended by counsel, but the other side isn't going to bite, and so you can have litigation that continues on and on and on, because even though there's a reasonable settlement offer on the table, there are legitimate reasons not to resolve, and there's always a reputational issue. I find your insureds can get a little caught up in that, which makes handling these claims always a little bit tricky. Again, it's not like an MVA claim where you can just the insurer carries the day. Insureds have a lot of input because they have a lot of skin in the game. When you're handling these claims, they can be front loaded. There's a lot of work up front. You got to get the information. There's usually been a series of events that have led up to the claim. You'll want to make sure you get that. You want to make sure your insured is providing you any demand letters they got before the claim came in. A common thing with employment law is that you can have sort of pre-discovery mediations are very common, because in some cases it is usually just about reasonable notice, and the question is, how much is one person willing to pay and how much is one person willing to take, and you can get those issues narrowed down pretty quickly. And so when your defense counsel says, oh, a pre-discovery mediation might be an idea, it's not an unusual thing to have happen, and they can be pretty cost effective. And summary judgments are very common in employment law, and these sorts of EPL claims, as long as there's not a lot of additional claims on the side. The Supreme Court of Canada has basically said summary judgment is the way to go for wrongful dismissal claims, and so you can have these claims adjudicated pretty quickly, but again, very front heavy, and there can be a lot of work on the front. And it's sort of interesting as well, because employment claims, there is this tension because they don't get better with age for the plaintiff, because they will often find another job and mitigate their losses. So the longer a claim goes on, sort of the better for the insurer or the insured, but at the same time, it can be a little, there's a benefit to getting them resolved early, and they are often very front loaded because they can be straightforward to a certain degree. And so to sort of wrap this up, what are some claims handling tips that you might want to know? The single most important thing is to get a copy of the contract of employment that your insured has with the plaintiff. And there is a 50% chance that there's no written contract of employment, but you need to know that. When you get the claim in, you do want to get a sense of what the claim is really about. I've had files where I get the statement of claim, and the allegations are essentially, the employer, essentially dismissed them because they took a leave of absence for health issues, and they complained of harassment by someone, and as a result, the employer dismissed the employee as a reprisal. But then when you actually look at the file and you can look at the notes, or if there are minutes from the insured, it's separate issues. The person was dismissed because of financial considerations. They switched to an outside contractor, and so you really want to get a sense of what the claim is about early on, because that's going to frame how you approach it. Is this going to be one that you need discoveries and you need a lot of time to work it through, or is this one where you can get it settled relatively early? You want to know if the employer dismissed the employee for cause, because if they did, that's going to have a lot more exposure, because there is concerns about bad faith, and there might be these defamation claims. There's a lot of, you want to get a sense early on, what happened, what's claimed, and what are the main documents you need. And when you're handing it off to defense counsel, you want to be really clear to the insured and to us, what the coverage areas are. Does the policy, because I can't give, when I'm defense counsel, I can't tell my insured about coverage or anything like that. So you need to be really clear. Is this only a defense costs file? Is there some indemnity that could be paid out depending on the types of damages? You want to be really clear about that. And certainly something to consider in settlement. I've had files where, the insurer might chip in slightly more to get a file settled because the legal spend on this is going to outstrip the damages, which can happen as well. So again, just be very clear on coverage after that last bit. And so to wrap it up, and I see I've got 2 questions and I've got a couple minutes left. Employment practice liability claims, they are a lot broader than you think. They can be really complicated. And so they really do warrant, both from a coverage perspective and defending, they warrant taking a little bit more time with them, which can be tricky. We're all busy, but it really pays to front load the work. Also try and figure out what the claim is about, and just get as much information from your insured as possible, because while insureds are generally pretty cooperative, there is often a lot more documentation that's in the background that you and defense counsel really are going to want to look at before you set your exposure analysis. And so I just want to, that's got 2 questions here. All right. And so the first question I have is, assuming the EPL premium would be based on payroll and budgeted value. Excellent question. I'm not an underwriter, but so they may be the best options. But yeah, usually size of the employer is going to be a big issue. Employers who have a payroll of over $2.5 million in Ontario have additional obligations to pay out statutory severance. So certainly payroll is going to be a factor in premiums, claims history, whether you have workplace policies in place, things like that. It's, these applications are actually pretty long these days. It's gone are the 1-pagers. It's 14 pages of detailed questions. And then I've got another question here. So we've got a vaccine policy case. So an insured a certain date, if you can't prove the vaccination, you'll be put on leave until you can provide it. There are issues about constructive dismissal. This is actually a pretty technical question, so I might suggest that we can answer this offline. But yeah, workplace policy implementation is a big issue. You'll see people, vaccine policies are the big issue now. People will claim that they've been wrongfully dismissed, either literally or constructively, which means the employer has changed the job so much, it's not the same. And so you'll get these wrongful dismissal claims because they've implemented policies without notice. And so for this question, just I'll send me an email after this and we can chat, because there's a lot to it. Sorry if that's not the specific answer you're looking for, but vaccine policies are sort of the hot topic these days, and certainly warrant a bit of a discussion. And so those are the two questions I had. I see we're at 1 o'clock, so I want to be respectful of everyone's time. So just before we go, what's up next? We've got on March 9th, my colleague Laura Emmett in the London office is going to be talking about what to expect when you're expecting a claim, which essentially is going to be claims handling advice. And then the MIG update 2022 from my colleague Julianne, who's in the Toronto office. Everything you need to know about the minor injury guideline under accident benefits here in Ontario, and that's coming up on March 31st. So otherwise, I believe that is our time, and thank you everyone for tuning in. And again, contact information is on the slides. You can find me on the internet or just email me, and this will be up on the website. Have a great afternoon.